it has changed the paradigm on the court. I think the newspapers are filled with reports about how many emergency motions we are receiving. It's unprecedented in the court's history. We've done it to ourselves.
That was Supreme Court Justice Sonia Sotomayor's recent warning about the court's unprecedented rulings on presidential power, hasty emergency decisions without much explanation, but with long-lasting implications, and more than 20 key victories for Donald Trump. But the origin story of the Supreme Court's so-called shadow docket has really been a mystery to normal people like us until now, until the New York Times recently published bombshell confidential correspondence between the justices during a pivotal 2016 ruling that transformed the court. From that reporting, quote, "In public, Chief Justice John Roberts has cultivated a reputation for care and caution. The papers reveal a different side of him. At a critical moment for the country and the court, the papers show he acted as a bulldozer in pushing to stop Mr. Obama's plan to address the global climate crisis. When colleagues warned the Chief Justice that he was proposing an unprecedented move, he was dismissive. Quote, Justice Breyer skipped over the question of whether the plan was lawful, asking only, why the rush? The circuit court had already set a date to hear the case in June. The Chief Justice wrote right back the next day, sounding irritated and blunt. Speed was vital, he said, because environmental regulation was going to be very expensive for states and the power industry. More from the Times reporting, quote, in the Trump era, Roberts and the other conservative justices have repeatedly empowered the president through their shadow docket rulings. By contrast, the papers reveal a court wielding those same powers to block Obama. Justice Samuel Alito warned that if the court failed to stop the president, its own, quote, institutional legitimacy would be threatened. I want to bring in New York Times investigative reporter Jodi Kantor. That is her reporting we just read on, our first real look at the shadow docket, how it came to be. Her new book, How to Start, Discovering Your Life's Work, is out now. It is must read for everybody. We'll talk about it in a minute, but also joining this part of the conversation, my friend and colleague, NYU law professor, legal analyst Melissa Murray is here as well. First of all, this reporting on sort of one of the enduring mysteries of why things are so messed up, to use a non-SCOTUS kind of word, is amazing. Just tell us what you were able to report.
Oh, well, thank you. Adam Liptak and I did it together. And the way I would explain it is like this. When we think of a Supreme Court case, we think of a slow, deliberate, careful process.
Right.
These cases,
where they're like nice to each other behind the scenes.
Well, where they're looking very carefully at the issues, they take their time. These cases can unfold over a year. There are oral arguments in person. The justices are sitting in conference meetings, really discussing and voting on the cases. These shadow docket cases are very abbreviated. They happen, this is 5 days worth of memos that we published. They're also very secretive. If you look at the order that the court issued, it is terse. It's about 142 words. It's little more than one paragraph. And there's legal boilerplate and there is instruction, but there's no explanation. And the reason that is surprising is that courts get their authority from explaining themselves. Most of the time, a judge has to write an opinion, right? And because our judges, especially our federal judges, are appointed for life, they're not really accountable in other ways. The act of writing an opinion for a judge is saying, this is why you should trust me, not blind trust. But even if you disagree with the decision, even if it's something that affects you in a negative way, I want to show you that I've done my work. These shadow docket opinions, many of them have little to no explanation. So Adam and I started by asking, how did this start? We knew that about 10 years ago was when things changed. How did the court disregard time-tested procedures and get to this fast-track way of doing business? And these memos allow us to listen to the justices as they're deciding to do that.
Well, they sound like partisan jerks.
You know, it's Adam and I wondered how people were going to react when.
Well, let me just be more specific. Worrying about the power companies' costs sounds like a less than patriotic duty for a person who's on an institution where there are only 9 of them, where you think in private they're worried about the country, they're worried about the law. To hear Roberts concerned about the expense for the power companies was disturbing.
Well, what's interesting is that in the set of papers we published, nobody mentions climate change, not the Democratic appointed justices, nor the Republican appointed justices. The main thing that occurred to us, honestly, is that they sound like they're in a rush. This is an incredibly consequential decision. Like, in retrospect, the court halting this plan was the beginning of the end of federal efforts to regulate greenhouse gas emissions. It's also a change in the way the court did business, because the D.C. Circuit was set to work on the case and the Supreme Court leapt in front of it. And they don't, like, the Chief Justice was very dismissive in these papers when confronted with his colleagues' procedural objections. So you just get the feeling, that this wasn't done with maximum Supreme Court care.
But why go so fast on a case like that and not on the cases that would have allowed the country to hear the evidence against Donald Trump? I mean, speed obviously is a subjective choice. How do they wield it?
I can't exactly answer what the rush was here. I think to do that would be to enter the mind of the justices. But that is the question that Justice Breyer asked. What is the rush here? And there is a clue, which is that we see that there was a power struggle between President Obama and his EPA on the one hand and Chief Justice Roberts on the other. There was a previous case in which the Chief Justice felt that the EPA had managed not only to sidestep the court, but had publicly almost bragged about it. And he essentially says, I am not going to let us be sidelined again.
Melissa, there's a thing with covering Trump for 9 years where when McConnell speaks on tape to reporters and it's leaked, it's never a more flattering portrait of Donald Trump. McConnell's comments are always more scathing. The Supreme Court now falls, the conservatives fall into that category too, that when there's a revelation, it never is more flattering than the public image, which I think the public, according to Gallup, has the lowest view of the Supreme Court since Gallup has been asking the public what it thinks of the Supreme Court. It's dropped farther than any other institution. This story falls in that category where their correspondence between themselves makes them look worse than even I thought they did today.
I'm not actually surprised to hear, Nicole, by what I saw and what Jody and Adam reported on. Again, I think you have to just sort of start with the fact that the New York Times, one of the most venerable papers in the country, has decided to put a Pulitzer Prize-winning investigative reporter on the Supreme Court beat. I think that by itself is really important to acknowledge. The public is tired of the lack of transparency around the court. The shadow docket is just part of it. I mean, when you add this revelation on top of the revelations about the justices' cozy relationships with certain donors, with individuals who have business before the court. The fact, and Jody reported on this a couple of years ago, that regulated industry and conservative causes have gone through great lengths, including buying a building across from the Supreme Court in order to be able to casually run into the justices and curry favor with them at different moments. You get a much more startling picture of an institution that is insulated from the public, but not insulated from these special interests. And this particular episode that Jody and Adam have reported on, where they're talking about the Chief Justice, who, as Jody says in her comments, has bulldozed through ordinary procedure because he is so deeply concerned about the impact of the Clean Power Plan on regulated industry, on the domestic power sector. I think all of that brought together presents something that for much of the public seems really out of bounds. A court that is not necessarily doing the work of the law, not necessarily doing work in the public interest, but perhaps in the interests of other interests.